Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in BLOM Bank SAL v. Honickman. In this case, the court considered this issue. Does Federal Rule of Civil Procedure 60B, 6S stringent standard apply to a post-judgment request to vacate for the purpose of filing an amended complaint? The case was decided on June 5, 2025. The Supreme Court held that relief under Rule 60B, 6, requires extraordinary circumstances, and this standard does not become less demanding when the movant seeks to reopen a case to amend a complaint. A party must first satisfy Rule 60B before Rule 15A's liberal amendment standard can apply. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Federal Rule of Civil Procedure 60B permits a district court to grant relief from a final judgment in limited circumstances. The rule includes 5 provisions setting out specific grounds upon which parties may seek such relief. It also includes a catch-all provision that allows a district court to relieve a party from a final judgment for any other reason that justifies relief. We have consistently held that only extraordinary circumstances can justify relief under the Rule 60B, 6, catch-all. The question presented is whether this rigorous standard applies when a Rule 60B, 6, movant seeks to reopen a case for the purpose of filing an amended complaint. We hold that it does. Plaintiffs, respondents here, are victims and the families of victims of terrorist attacks carried out by Hamas between December 2001 and August 2003. On January 1, 2019, plaintiffs sued petitioner BLOM Bank SAL, BLOM, an international bank, under the Anti-Terrorism Act, as amended by the Justice Against Sponsors of Terrorism Act, JASTA, 18 U.S.C. Section 2333d. They allege that BLOM aided and abetted Hamas's commission of the terrorist attacks by providing financial services to customers who were allegedly affiliated with Hamas and who had helped further Hamas's goals. In the district court, BLOM repeatedly argued that the facts alleged in plaintiff's complaint were insufficient to state a claim of aiding and abetting under JASTA. Before moving to dismiss the complaint, BLOM made this argument to the district court in a required pre-motion letter. Plaintiffs responded that they would stand on their allegations as pleaded. At a subsequent pre-motion conference, plaintiffs' counsel reaffirmed their client's position, telling the district court that they were prepared to brief their opposition to a motion to dismiss based on the arguments presented in the pre-motion letter, and that they would not seek leave to amend if the court dismissed their complaint. BLOM moved to dismiss under Federal Rule of Civil Procedure 12b, 6. At a hearing on the motion, the district court reminded plaintiffs' counsel that they had not requested an opportunity to replead, and specifically asked whether this meant that the complaint contained everything the court would need to consider in terms of sufficiency of plaintiff's pleading. Plaintiffs' counsel confirmed that they did not intend to add any additional facts. The district court dismissed the complaint with prejudice and so denied leave to amend. The court held, as relevant here, that plaintiffs had not plausibly alleged the general awareness element necessary to plead JASTA aiding and abetting liability. In the district court's view, it was not enough for plaintiffs to plausibly allege that BLOM was generally aware of its role in terrorist activities, from which terrorist attacks were a natural and foreseeable consequence. Rather, plaintiffs needed to plausibly allege that, by providing financial services to specific customers, BLOM generally assumed a role in Hamas violent or life-endangering activities, and plaintiffs had failed to do so. And, the court explained, leave to amend was unwarranted because plaintiffs did not request leave to amend, specifically declined the court's offer to do so at the pre-motion conference, and further failed to identify any additional facts they could allege which would address the deficiencies in their complaint. The district court thus made an exception to its usual practice of granting plaintiffs an opportunity to amend their complaints following dismissal. Plaintiffs appealed to the Second Circuit, arguing that they had pleaded facts sufficient to support their aiding and abetting claim. The Second Circuit concluded that the district court had misinterpreted the general awareness element to impose an unduly high foreseeability requirement. But, even applying its less exacting standard, the Second Circuit determined that the facts alleged in the complaint did not plausibly support an inference that BLOM had the requisite general awareness at the time that it provided banking services to the customers allegedly affiliated with Hamas. The court thus affirmed the district court's judgment of dismissal. Plaintiffs returned to the district court and moved under Rule 60b, 6, to vacate the court's then affirmed final judgment so that they could file an amended complaint. They argued that the district court should give them an opportunity to meet the standard outlined by the Second Circuit. The district court denied their request. Specifically, it rejected plaintiffs' contention that the Second Circuit's clarification of the aiding and abetting standard constituted extraordinary circumstances sufficient to justify relief under Rule 60b, 6. That argument, according to the district court, ignores the principle that a mere change in decisional law does not constitute an extraordinary circumstance. In any event, the district court continued, any amendment would likely be futile because it was not clear that plaintiffs could succeed even under the clarified standard laid out by the Second Circuit. The district court added that plaintiffs' litigation choices further counseled against relief under Rule 60b, 6. The court explained that plaintiffs had ample opportunity to pursue all legal avenues available to them for relief, and sought post-judgment amendment despite having declined 2 prior opportunities to amend their complaint in the ordinary course, and after unsuccessfully appealing the dismissal of that complaint with prejudice. The district court declined to overlook plaintiffs' documented series of deliberate choices not to cure the deficiencies identified in their pleading. On appeal, the Second Circuit again disagreed with the district court. It acknowledged that a plaintiff is ordinarily entitled to Rule 60b, 6, relief only under extraordinary circumstances. But, it asserted, when a party seeks vacatur under Rule 60b to obtain leave to file an amended complaint, special considerations come into play. In that circumstance, the court held, the district court must give due regard to both Rule 60b's philosophy favoring finality of judgments, and the liberal amendment policy of Rule 15a, which requires courts to freely give leave to amend pleadings before trial when justice so requires, Fed. Rule Civ. Proc. 15a, 2. In other words, courts must balance the competing standards by considering Rule 60b finality and Rule 15a liberality in tandem. The Second Circuit held that the district court had abused its discretion by incorrectly treating plaintiffs' motion to vacate and amend as calling for 2 distinct analyses, requiring plaintiffs to successfully navigate Rule 60b's finality gauntlet before they could invoke Rule 15a's liberal repleading policy. We granted certiorari. Relief under Rule 60b, 6, requires extraordinary circumstances. That standard does not become less demanding when a Rule 60b, 6, movant also hopes to amend his complaint. Rather, a party seeking to reopen his case and replied must first satisfy Rule 60b on its own terms and obtain Rule 60b relief before Rule 15a's liberal amendment standard can apply. Because the Second Circuit's balancing approach conflates this order of operations and dilutes Rule 60b, 6's well-established standard, we must reject it. Rule 60b allows a party to seek relief from final judgment and reopen a case based on mistake or excusable neglect, newly discovered evidence, fraud, or the void or prospectively inequitable status of a judgment. Rule 60b also includes a catch-all provision, Rule 60b, 6, that allows a district court to reopen a case for any other reason that justifies relief. A party seeking relief based on the grounds covered by paragraphs 1 through 3i.e., mistake or excusable neglect, new evidence, or fraud, faces a 1-year limitations period. That time bar, however, does not apply to motions for relief filed under Rule 60b's other paragraphs, including Rule 60b, 6. The text and structure of Rule 60 make clear that relief under Rule 60b, 6, is available only in narrow circumstances. Rule 60b, 6, is a catch-all that follows paragraphs 1 through 5. It covers any other reason that justifies relief. That is, Rule 60b, 6, provides only grounds for relief not already covered by the preceding 5 paragraphs. Were it otherwise, the catch-all provision could swallow the preceding paragraphs and be used to circumvent their time bars. Such a broad interpretation of Rule 60b, 6, would thus violate a cardinal principle of statutory construction by making the preceding paragraphs and their limitations period superfluous. Thus, we have repeatedly held that relief under Rule 60b, 6, is available only when Rules 60b, 1 through b5, are inapplicable. But, even then, extraordinary circumstances must justify reopening. The court identified such circumstances for the first time in Clappert v. United States, decided shortly after Rule 60b, 6's adoption. There, the petitioner sought to set aside a default judgment entered in denaturalization proceedings. His allegations set up an extraordinary situation. The petitioner was in jail, weakened from illness, without a lawyer in the denaturalization proceedings or funds to hire one, and disturbed and fully occupied in efforts to protect himself against the gravest criminal charges in separate proceedings. He was therefore no more able to defend himself in the denaturalization proceedings than he would have been had he never received notice of the charges. On these facts, the court found that relief under Rule 60b, 6, was justified. The court underscored the stringency of the extraordinary circumstances test a year later in Ackerman v. United States. The petitioner there had suffered an adverse denaturalization judgment and declined to appeal. 4 years later, he sought to vacate the judgment under Rule 60b, 6, alleging that it was erroneous, and that he had declined to appeal due to expense and the advice of a third party. The court held these circumstances insufficient to satisfy Rule 60b, 6s strict standard. Compared to the situation in Claprit, the Ackerman petitioner's allegations highlighted the difference between no choice and choice, imprisonment and freedom of action, no trial and trial, no counsel and counsel, no chance for negligence and inexcusable negligence. The court emphasized the importance of a Rule 60b, 6, movant's faultlessness, explaining that there must be an end to litigation someday, and free, calculated, deliberate choices are not to be relieved from. Our more recent cases have consistently reaffirmed that Rule 60b, 6, should only be applied in extraordinary circumstances. This very strict interpretation of Rule 60b is essential if the finality of judgments is to be preserved. The Rule 60b, 6 standard does not change when a party seeks to reopen his case to amend his complaint. In that circumstance, satisfaction of Rule 60b, 6, necessarily precedes any application of Rule 15a. Rule 15a's liberal amendment policy therefore cannot weaken Rule 60b, 6's extraordinary circumstances standard. Rules 60b and 15a apply at different stages of litigation and demand separate inquiries. Rule 15a governs pretrial amendments, and sets forth a standard under which courts should freely give leave when justice so requires. The rule's purpose is to provide maximum opportunity for each claim to be decided on its merits rather than on procedural technicalities. That standard, however, does not govern when, following a final judgment, the case is closed and there is no pending pleading to amend. A contrary approach would enable the liberal amendment policy of Rule 15a to be employed in a way that is contrary to the philosophy favoring finality of judgments and the expeditious termination of litigation. Thus, we disagree with the Second Circuit's holding that the district court should have used a hybrid standard to consider Rule 60b finality and Rule 15a liberality in tandem. It is Rule 60b standard, and only Rule 60b standard, that applies when a party seeks relief from final judgment. A party seeking Rule 60b, 6, relief must always demonstrate extraordinary circumstances justifying relief. What he intends to do if his case is reopened does not alter that standard. In other words, the district court was correct to treat plaintiff's motion to vacate and amend as calling for two distinct analyses, with the question of vacatur under Rule 60b, 6, preceding that of repleading under Rule 15a. None of our analysis, however, should be taken to suggest that a district court contravenes Rule 60b merely by considering a movant's desire to amend his complaint. For example, where a party seeks vacatur in order to amend its pleadings, a district court is free to cite Rule 15 and acknowledge amendment-related considerations, such as whether a movant has had the opportunity to amend, and the amendment standard that the party will eventually have to meet if the Rule 60b motion is granted. What a district court may not do is what the Second Circuit demanded here: dilute Rule 60b, 6's stringent standard by balancing it with Rule 15a's liberal pleading principles. Plaintiffs insist that the Second Circuit's approach is consonant with Rule 60b, 6, and our precedents interpreting that provision, but their arguments are unpersuasive. Balancing the strict standards of Rule 60b, 6, against the more relaxed standards of Rule 15 necessarily weakens the former, and is thus incompatible with our long line of precedents holding that Rule 60b, 6, should only be applied in extraordinary circumstances. Even the Second Circuit appeared to acknowledge that its test departed from the ordinary approach to Rule 60b, 6, under which a plaintiff may receive relief only by demonstrating extraordinary circumstances, and showing that the asserted grounds for relief are not recognized in clauses 1, 5, of the rule. Nor does this court's decision in Foman v. Davis help plaintiffs. The Foman court held that the district court's denial of the petitioner's motions to vacate the court's judgment and amend her complaint rested on technicalities that ran contrary to the spirit of the federal rules of civil procedure. But, Foman dealt with Rule 59e, not Rule 60b, and Rule 60b differs from Rule 59e in just about every way that matters to the inquiry here. Most relevant, a Rule 60b motion threatens an already final judgment with successive litigation, and a motion under Rule 60b, 6, in particular, may threaten final judgments years after they are entered. In contrast, the filing of a Rule 59e motion within the 28-day period suspends the finality of the original judgment, and only the disposition of that motion restores the finality of the original judgment. Because Rule 59e does not threaten the finality of judgments to the same degree that Rule 60b, 6, does, we do not require a movant to show the same extraordinary circumstances to receive relief. We also disagree with the Second Circuit's disposition of this case. District courts' Rule 60b rulings are reviewed only for abuse of discretion. That standard is limited and deferential. To be upheld, a district court's decision need only apply the correct legal standard and offer substantial justification for its conclusion. The district court's determination that plaintiffs failed to demonstrate any extraordinary circumstances warranting relief under Rule 60b-6 easily clears that bar. For the reasons we have explained, the district court was correct to evaluate plaintiffs' motion under only Rule 60b's standard, and the district court offered persuasive justifications for finding that standard unsatisfied, that the Second Circuit's clarification of the test for aiding and abetting liability did not constitute extraordinary circumstances, particularly when plaintiffs were unlikely to succeed under that standard, and that plaintiffs' series of deliberate choices not to cure the deficiencies identified in their pleading also cut against them. Those justifications follow from core tenets of Rule 60b doctrine. The district court's decision therefore fell within the wide range of choice afforded under the abuse of discretion standard. The Second Circuit erred in holding otherwise. The judgment of the Second Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Jackson, concurring in part and concurring in the judgment. I join all but Part 3 of the court's opinion. I agree with the court's conclusion that, when a district court considers a movant's desire to amend his complaint in the context of a motion to reopen a case under Federal Rule of Civil Procedure 60b-6, the Rule 60b-6 standard, rather than the Rule 15a standard, applies. Given the deference owed to lower courts with respect to Rule 60b-6 determinations, I also agree that the district court did not abuse its discretion in denying reopening here. I write separately to emphasize that our affirmance of the district court's denial of reopening in this case does not require accepting all aspects of the district court's reasoning. In particular, I think the district court was wrong to fault plaintiffs for making a deliberate choice to appeal the dismissal of their complaint in lieu of accepting various pre-dismissal opportunities to cure purported pleading deficiencies. The district court based that aspect of its reopening determination on our opinion in Ackerman v. United States. But, as I explained below, the choice that plaintiffs made, declining to amend, does not categorically preclude Rule 60b-6 relief under that precedent. Rule 60b permits district courts to reopen cases after the entry of a final judgment under a limited set of circumstances including fraud, mistake, and newly discovered evidence. In Gonzalez v. Crosby, we described this rule as attempting to strike a proper balance between the conflicting principles that litigation must be brought to an end and that justice should be done. The sixth paragraph of Rule 60b is the provision at issue here. It is a catch-all that permits reopening for reasons not covered in the rule's preceding 5 paragraphs. In Kemp v. United States, we noted the opening paragraphs of subsection B specifically enumerate various bases for relief: mistake, newly discovered evidence, fraud, and the voiding or satisfaction of a judgment. Then, under paragraph 6, a court may, on motion and just terms, reopen a judgment, order, or proceeding for any other reason that justifies relief, provided that the motion is filed within a reasonable time. Because of the mutually exclusive nature of Rule 60b's provisions, as explained in Pioneer Investment Services Company v. Brunswick Associates L.P., this court has long held that relief under Rule 60b-6 is available only in narrow circumstances. We have thus required Rule 60b-6 movants to demonstrate that extraordinary circumstances justify reopening the case. In this court's first case applying Rule 60b-6, Clappert v. United States, we concluded that reopening was warranted where a movant alleged an extraordinary situation, namely, that he had been stripped of his citizenship by default judgment while he was, among other things, incarcerated and in ill health. The court considered a similar Rule 60b-6 request for reopening in the context of a denaturalization proceeding 1 year later in Ackerman, and reached a different outcome. We upheld the denial of the Rule 60b-6 motion, expressly distinguishing Clappert. Critically, the movant in Ackerman had sought reopening only after making a considered choice not to appeal the adverse judgment. Given the need for an end to litigation someday, we explained that a movant cannot be relieved of such a choice because hindsight seems to indicate to him that his decision not to appeal was probably wrong. Under this line of precedent, the court has concluded that due diligence by the movant is a prerequisite to obtaining Rule 60b-6 relief. For that reason, we have consistently found reopening inappropriate where, as in Ackerman, a movant deliberately terminated the underlying litigation. A decade after Ackerman, for example in Polites v. United States, we held that a Rule 60b-6 movant who had abandoned his appeal from a denaturalization judgment due to its perceived small likelihood of success was not entitled to reopening under Rule 60b-6, where he could not otherwise demonstrate extraordinary circumstances. More recently, in Gonzalez, we found reopening inappropriate when a movant had abandoned any attempt to seek review of the decision in question. Relying on Ackerman, The district court below suggested that plaintiffs could not demonstrate extraordinary circumstances because they had made a documented series of deliberate choices not to cure the deficiencies identified in their pleading. The district court thus faulted plaintiffs for believing that their complaint alleged sufficient facts and declining to amend it. They opted instead to seek clarification from the appeals court regarding the sufficiency of their pleading. In my view, the district court should not have assumed that Ackerman's lack of due diligence principle applies under these circumstances. Plaintiffs did not abandon this litigation. Instead, they diligently pursued their statutory right to appeal on the grounds that, in their view, the district court had mistakenly concluded their complaint was insufficient, as noted in Wietzig v. Halliburton Energy Services Incorporated. To be sure, the courts below did ultimately find that the factual allegations in plaintiffs' complaint were deficient, but that just means that plaintiffs were overconfident about the strength of their pleading and their prospect of success on appeal. A misstep of this nature is not abandonment, far from it, and the fact that a plaintiff opts to appeal does not alone preclude Rule 60b-6 relief, provided that he can otherwise demonstrate extraordinary circumstances and has not exhibited neglect or lack of due diligence. As stated in Lilleberg v. Health Services Acquisition Corporation, in Buck v. Davis, we held that the use of race-based considerations at sentencing in a capital case was an extraordinary circumstance warranting reopening even though the movant's counsel had introduced the evidence in question. The bottom line, jurisprudentially, is that courts should refrain from reflexively denying reopening for amendment purposes when a Rule 60b-6 movant's only purported fault was a prior decision not to amend the complaint. A plaintiff may have good reasons for seeking clarification from an appeals court before taking the significant step of amending his pleading. In this case, for example, plaintiffs allege that BLOM Bank SAL aided and abetted Hamas's commission of certain terrorist attacks by providing financial services to customers who were allegedly affiliated with Hamas and who had helped further Hamas's goals. These are serious allegations. One would reasonably expect plaintiffs to exercise great caution before making additional factual assertions that further link BLOM to alleged terrorist activities. Moreover, and importantly, denying reopening after appeal merely because the plaintiff previously declined to amend the complaint risks undermining the statutory right to take an appeal from any final decision of a district court, as emphasized in Wietzig. If a plaintiff is necessarily at fault for Rule 60b-6 purposes just because he exercised his right to appeal, then plaintiffs will be disincentivized to go to the courts of appeals even when they reasonably believe the allegations in their pleadings are sufficient. That outcome not only divests them of their right to appellate review, but could also leave important legal questions regarding pleading sufficiency unanswered. It is particularly inappropriate to deny Rule 60b-6 reopening based on a prior refusal to amend where a clear, intervening change in the law supplies the necessary extraordinary circumstances. In Kemp v. United States, Justice Sotomayor's concurrence detailed this court's settled precedents recognizing the availability of Rule 60b-6 to reopen a judgment in extraordinary circumstances, including a change in controlling law. To treat the plaintiff's prior refusal to amend as dispositive in such a situation would be manifestly inconsistent with the preference expressed in the federal rules of civil procedure in general, for resolving disputes on their merits, as noted in Krupski v. Costa-Croquier S.P.A. This court reviews the denial of a Rule 60b motion only for an abuse of discretion, and does not opine here, in the first instance, as to whether these plaintiffs have demonstrated extraordinary circumstances. The district court's primary justification for denying plaintiffs' motion to reopen was that the Second Circuit's clarification of the applicable legal standard did not qualify as an extraordinary circumstance, particularly when plaintiffs were unlikely to prevail even under the clarified standard. I concur in today's judgment because I agree that the district court did not abuse its discretion with respect to denying Rule 60b-6 relief on that basis. But I find the district court's alternative ground for denying reopening, that plaintiffs were at fault because they declined prior opportunities to amend their complaint, neither persuasive nor consistent with core tenets of Rule 60b doctrine. Assuming extraordinary circumstances otherwise exist, a plaintiff should not be faulted under Rule 60b-6 for reasonably having chosen to appeal rather than amend his complaint. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.